One of the things that grandparents fear the most is being cut off from their grandkids. Often other family members such as aunts, uncles, and cousins feel the same way. Some step-parents dread the thought of being denied contact with their stepkids if they separate from the parent of those children. So, when the Ontario government made changes to the family law legislation in 2021, it made it specifically possible for these non-parent family members to go to court and get orders to let them see and even make decisions for kids. I'm John Schuman, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. Grandparents and other important people to a child can ask a judge to make an order permitting them to have time with the child and perhaps even decision-making responsibilities. These other important non-parents can lose contact with the child either because of the parent's divorce or at other times when the important non-parents don't get along with the parents. The rights of grandparents and other important people are a little different in each type of situation. Non-parent family members and others do not have the same ability to seek the same orders that biological and adoptive parents or step-parents do in a divorce proceeding. When a child's parents are getting divorced, only the divorcing spouses have an automatic right to ask for parenting orders. Others, including biological or adoptive parents who are not one of the divorcing spouses, must ask the court for permission to be involved in the divorce proceeding. For example, when a parent remarries, his or her ex does not have an automatic right to seek parenting time in the parent's second divorce. As I covered in episode 59, courts do not make orders for custody and access. When it comes to separated parents, judges make orders for parenting time and decision-making with respect to children. Only a child's biological or adoptive parent, step-parent, or another person who is acting like a parent to the child can seek an order for decision-making. All others, including grandparents, other family members, and others with a close relationship with the child, can only ask the divorce court to make a contact order allowing them time, but not parenting time with the child. However, before making an order for contact time, the judge hearing the divorce must consider whether the person asking for contact time could get it without an order during the parenting time of one of the spouses. If a parent will share their parenting time with a non-parent, then there is no need for a contact order. Things are a little different if a grandparent, family member, or other person wants to start their own court proceeding to get a parenting order. This happens when the relationship breaks down with one or both parents and they get cut off from the kids. Where that important person was not married to one of the parents, he or she can ask for an order under Ontario's Children's Law Reform Act. A person who is an adoptive or biological parent of a child or who has a court order recognizing him or her as a parent of the child can seek an order for parenting time and decision making. Again, see episode 59 and my book for more about these orders. Grandparents and anyone else who is not legally recognized as a parent can start court proceedings to ask a judge for parenting orders with respect to decision making or for a contact order that allows them time with the child. Non-parents have some additional steps that they must take if they want an order for decision making or a contact order. They must file 2 extra documents with the court: a recent police record check and the required form authorizing Ontario Children's Aid Society to provide a report directly to the court about whether the non-parent has had any involvement with the Children's Aid Society. That must be done at the same time the non-parent files his or her initial court documents, which must include a longer version of the Form 35.1 affidavit that parents must also file with the court. In addition, when a non-parent starts a court proceeding regarding parenting, the court clerk does a court's record search to find any current or previous family law proceedings involving the non-parent. A judge can also require the court clerk to do a search of any criminal court proceedings that involve the non-parent, which can show proceedings that might not show up in the police record check. Anything relative to parenting ability that comes up from those steps is admissible as evidence in the proceedings to assist the court in determining what order is in the child's best interest. The grandparent, step-parent, family member, or other non-parent can then proceed to seek a parenting order from the court using the usual family court procedure, which I set out in earlier episodes and in my book. However, non-parents will still have a difficult time getting an order for decision-making or contact time over the objections of a child's parents. The Ontario Court of Appeal decided that, in the absence of any evidence that the parents are behaving in a way which demonstrates an inability to act in accordance with the best interest of their children, their right to make decisions and judgments on their children's behalf should be respected, including decisions about whom they see, how often, and under what circumstances. Anyone who seeks a court order for time with a child, be it an order for parenting time or a contact order, also need to realize that if they get that order, they will be under a legal obligation to keep the child's parents informed about where they live, and they will also have a legal obligation to tell the child's parents if they move. They won't be able to run away and hide from the child's parents, and will have to share their contact information until the child turns 18. There is another reason why grandparents, step-parents, and others may want to pause before seeking a parenting order. That is because doing so may create a child support obligation for them. Grandparents who act like grandparents do not have to worry about this. But anyone who demonstrates a settled intention to treat a child as his or her own and stand in the place of a parent can make them liable for child support to the child's other parents. If you want more information about grandparents, step-parents, or others having to pay child support, or if you need some more general family law or children's law guidance, or you need to understand Ontario family law better so you can make better decisions, if you need to know the best parenting options after separation, or if you need to understand how finances work during a marriage or common relationship and after separation or divorce, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook store, on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. You can also set up an appointment to speak to us by calling 416-446-547. It is always best to get a lawyer who can give you expert advice to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter at @SchumanFamLaw, and finding me on LinkedIn. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. Or you can get all the episodes at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.